All rise. Court of Appeals, Division 1 is now in session.
Good morning. You may be seated. We are here on our case number 1CACV150721, Cabral House, LLC versus Arizona Department of Economic Security, Division of Developmental Disabilities and Access. Counsel, as you know, each side's allotted 20 minutes for your argument. The appellant may reserve any amount of time you'd like to use in rebuttal. If you do decide to reserve some time, though, you're in charge of keeping track of your own time, because the clock on the podium will reflect the total that you have, including what you may have decided to reserve. We record these proceedings, so when you approach the podium, we'd be grateful if you would give us your name and the name of your client for the recording. We have read the briefs. We've looked at the administrative record in some detail. We've also discussed the case in our conference. So with that, you may proceed.
Thank you. I am John Call, and I represent Cabral House. This matter does sound in contract, and what's happened in this case is the proceedings below failed to look at this as a contract matter that Cabral House has. So I'd like to just take a look at the big picture just for one moment before I jump into the weeds on this. And every year, millions and millions of dollars are received by Access under the Medicaid program for certain people of a certain class who have disabilities such as blindness, severe autism, such as Frank Ribello has. And Access gets that money, and they delegate that money to DES and their Department of Developmental Disabilities to administer the program. DES and DDD then further delegate this matter to subcontractors such as Cabral House. So it's analogous to a general contractor on a construction project hiring subcontractors. Okay, so for 10 years, Frank Ribello received 18 hours of habilitation. And what's notable is he received that at a 2-to-1 staffing ratio. This is a bit of a house cleaning matter, but it's sort of obliquely referenced in a number of places in the record, and I will come back around to that. But briefly, if you look at the one reference that I have is in the billing summary that's generated by DES DDD, and that is found at Index of Record, I believe page 6. And if you look at that, it shows Cabral House being paid at the $34.24 an hour race.
Yeah, 2 times. Yeah.
It is 2 times, correct. So that's undisputed, and it's undisputed that Frank Ribello received 18 hours of habilitation every day. Getting back to my analogy, so it's analogous to a subcontractor having a contract with a general contractor to paint houses and being told, look, you're going to paint 36 houses a year, and you're going to get paid as you go. And they submit a bill, and they don't get paid. And they say, wait, gee, what's wrong? And the general contractor says, oh, don't worry, we'll investigate that. So some time goes by. Just keep painting houses, don't worry, we'll take care of that. Okay, and that's analogous to the letter from Larry Latham, in this Assistant Director Larry Latham in this matter, who writes a letter and says, oh, we understand there's a forgery, we're going to investigate that forgery. So some time goes by, the general contractor keeps getting paid less money from what they're supposed to be paid, and then they get told, gee, you know, a salesperson in our house forged some contracts. We didn't really have 36 houses to paint. We only had 18 houses to paint. So we're only going to pay you for 18 houses because this unscrupulous salesperson forged some contracts. Now, that's a loose analogy, okay?
Well, Mr. Cole, let me stop you. I think we understand the analogy now, but focusing on the facts of this case, there was a contract between Cabral House and Access. It may have been with DDD, I forget. But that's the fact, and that contract obligated your client to perform services for the son, according to the ISP, according to his current ISP. I guess I don't understand what rights you're contending that contract afforded Cabral House to payment for services that were not specified in the then current ISP. The forgery issues, those were serious issues, but those were addressed in a separate appeal process by the parents. So viewing the contract, I guess I'm not seeing how the dispute about the ISP that the parents had bore on what Cabral House was expecting to receive in payment.
That's a very good question, and that's where the whole problem with this case is, okay? The separate issue with the parent is a collateral proceeding, okay? Under the Arnett, and they're trying to use that collateral proceeding to stop Cabral House from making contractual claims. Under the Arnett case, you cannot use res judicata in a separate proceeding where there's been a misrepresentation in the collateral proceeding.
Well, what contract? What am I getting wrong here? I understood that the contract obligated the state to pay Cabral House for performing services that were called out in the then current ISP. What in the contract obligated the state to pay for other services than were called out in the then current ISP?
Here, that's a very good question, and here is the problem. The contract itself puts an onus on Cabral House to follow state and federal law. We are saying that DES and DDD ignored federal law with regard to Frank Rebello's benefits. Just because DES and DDD acts unlawfully and uses a forgery to reduce benefits, okay, and here's where that's wrong. It's wrong in three ways. There's federal statutes under the federal code which require a due process hearing before reducing benefits. So what happened here is a caseworker forged an ISP on, I believe it was August 13th, 2012, indicating that there was an agreement to a reduction in benefits. If you look at the ISP,
does there have to be an agreement?
Yes.
For a reduction in benefits?
Or a hearing. If you look at the form itself, okay, there's check boxes for whether there's an agreement or not. The state's incorrectly arguing they can just change the benefits willy-nilly if they want. But that's not how it works. If you look at this form, if there's a disagreement, if there's a reduction, there's 30 days to request a review hearing, and then there's supposed to be a review on whether the reduction was proper or not.
Was the hearing sought after the August incident?
Yes, repeatedly. And here's what happened. They set a hearing, but they set a hearing for an increase in services, and they assumed that the forged ISP was actually a valid ISP where there was agreement.
I saw that in your briefing, the distinction that you draw between a hearing on a purported increase and what your clients would have contended was a decrease in services.
Correct.
What's the difference in the administrative process as to the outcome of that? Isn't the outcome of the administrative review a decision on what the ISP ought to be in any event, whether it's up or down?
So the burden of proof is different. Okay, so under both state statutes, and we've cited this in our brief, but the burden should be on the state to prove that the reduction is appropriate. In this instance, they put the burden on Cabral House. So this is in our procedural section of our brief, but the reviews that Cabral House got were simply paper reviews with no opportunity to be heard.
That the parents got, you mean?
Yes. I'm sorry, the parents. So, but independent of what's going on with Frank Ravello's individual rights, if you read the contract, okay, it says both DES, DDD and Access, and Cabral House are going to make sure that Frank Ravello's benefits and rights are protected. And there's numerous sections, and this is a big, long contract. The director found that Cabral House had a contract to provide benefits specifically to Frank Ravello. There's multiple sections in that contract that says, hey, you're going to follow state and federal law anytime there's a reduction in benefits. There never was. Now, they might say, look, what difference does it make? We had some hearings, but in this instance, it was quite significant. We don't get
What was quite significant?
the hearing, okay, the difference in the standard of proof.
Where's the standard of proof or the burden of proof? Is that specified in a statute or
Yes,
a rule?
it is. It's R219, I believe 119.
R2 119?
Yeah, and then there's an ARS section which applies, I believe, which is ARS 41-1092-07G. So it's quite significant in this case because we don't, over a year later, we don't get to an in-person hearing where they actually do a medical evaluation on Frank, and that takes place in front of Administrative Law Judge Dorinda Lang, and there's a decision from her, and this is at the Index of Record 7, page 208, and she cites her evidence, and one of the things that she considers is Rhonda Tarver went out and visited. Well, Rhonda Tarver is the person who forged 2 other people's service plans, so she weighs that. And then at page 3 of her decision, which would be 210 of the Index of Record, she considers a caseworker, Francine Waiters, who went out and visited for 6 hours. And she says, in the 6 hours, there was maybe one incident where he acted up and needed some intervention. And then the judge also heard from Kathy Maniscalco saying, look, he's a strong man. It takes 2 people to restrain him. We made a motion to supplement the record, and there's some photos of Frank, and because the photos in the record were unclear, he's tremendously strong. You can look at his biceps in that and imagine what it would take to restrain him. It takes 2 people. At any rate, Dorinda Lang gets through the proceeding, and she says, well, it's a preponderance of evidence standard, and I've got some evidence from a caseworker who went out there for 6 hours in person, and Rhonda Tarver, who is known to forge documents, and she says, I have to apply the preponderance standard and weigh it in favor of the state. You're not getting an increase in benefits. Let me just say, this has been mischaracteristically set as a request for an increase. The correct procedure under the law, which is 42 CFR 431.230 and ARS 36-565, says there's got to be 30 days notice. You're going to set it. There's going to be the opportunity to be heard. Okay.
So that was a proceeding that the parents raised with DDD.
Well,
Am I correct there?
Well, correct.
Okay.
But if you read the contract, Cabral House is responsible that these procedures are followed. If you,
Are you able to cite us with any case anywhere in the country that holds that a Medicaid contractor has the obligation or the power to determine the services?
yes, they have
that
standing.
That a client requires, contrary to what's specified in an ISP?
Okay, so, no, but I would submit that where an ISP is forged and the provider becomes aware of the forgery, the correct thing to do under the contract is to blow the whistle on the forgery, and this is very much a whistleblowing case, okay?
Do you think in the administrative review of the series of ISPs that the adjudicators were unaware that the parents had objected to the original change back in August of 2012? Do you think DDD was unaware that the parents objected to that change?
I can tell you DDD was unaware that there was a forgery, okay? And this case progressed along, and it's not until more than a year later that the forgery was discovered, and it happened in the course of a hearing where 7 days, November 20th, 2013, 7 days before that, the discovery packets provided, and Kathy Maniscalco, and this is in her testimony in the record, by the way, says, wait a minute, this isn't my signature. I never agreed to a reduction in services. She requests that this be investigated. It's almost 2 years after the fact that we get the internal affairs investigation saying it's not Kathy Maniscalco's signature. And so this case went very far down the road under unusual circumstances in this particular case. Incidentally, that report was not provided voluntarily. They had to get that through a public records request. The assistant director had said, we're going to investigate this. We'll get back to you if it turns out to be a forgery. And there was 2 letters he wrote. We'll take appropriate action at that time, leading Cabral House to believe, okay, they're going to do something about this. So there is a section of the contract that says that Cabral House will have its own system of adjudicating any grievances that Frank has. In this instance, DES and DDD acted unlawfully. They didn't follow the law. You know, in their brief, they cite ARS section 36565B for the proposition that they can set the amount of benefits, okay, any way they want. But what they don't cite is the following section, section C, which says, hey, if there's going to be a substantial change in benefits, there's going to be a hearing, 30 days, and the burden's going to be on DES DDD to justify the reduction, and that's never happened.
Slide again, 36-1.
They cite the statute in their brief, and they only cite section B, 36565, and it's BNC.
Okay.
So what's happening here is they're trying to pretend that Cabral House has no rights under its own contract. The contract is replete with incidents where if you know there's a fraud, you better do something about it. We've cited a statute in our brief. If you're aware of Medicaid fraud, you're supposed to report it, and the Attorney General is supposed to investigate it. What's happened in this case is we've just gotten a bunch of objections about its relevance instead of an investigation. We attempted to subpoena witnesses. That was objected to by the Attorney General. There's been no investigation whatsoever. We're asking for a reset in this case. They cite a case, ADAP, Arizona Association of Providers for Disabled Persons, and you asked me, is there a case in the land where a provider can stand in the shoes, and it's their case, okay? And we set this criteria out, but providers do have standing to challenge reduction of benefits to a recipient, okay?
Okay.
In this instance, we're just saying this impacts Cabral House, and Cabral House was harmed by this, and they were put in the awkward position of, there's a forgery reducing benefits, what do we do here? Well, the record's full of instances where Frank is a danger to himself, and it required two people to take care of him, and they kept providing benefits. We would like a reset in this case. We would like DES and DDD to be told, look, you can't reduce someone's benefits with a forgery. You should be setting a hearing on the reduction of benefits. And Cabral House would also like to be paid for the benefits that it provided during the black hole of time that went by while they investigated this forgery and did nothing about it. I see I have 30 seconds left, and I'm going to stop.
Very good.
Thank you.
May it please the Court. Logan Johnston on behalf of the Appalese Access and its director, Thomas Betlak, and with me is Joanne Falgout from the Attorney General's Office on behalf of the Department of Economic Security. Our thought, Your Honors, was that I would do the bulk of the argument, and if there is time left over that I don't use, or you perhaps have questions about DES that I can't answer, Ms. Falgout will jump in. I think it's important to remind us all at the outset that this is not a case about Frank and his appeals of decisions made by DES or their procedures with respect to anything they did with him. I say that because almost all of what you just heard and almost all of the appellant's briefs have to do with Frank's rights, not Cabral House's. We are here in this case because the Maniscalcos, after losing several appeals that they brought on behalf of Frank, finally filed a claims dispute on their own behalf as the owners of Cabral House, arguing that they are owed $352,000 for services that were not necessary and that were not authorized. With respect to those claims for payment to Cabral House, it is undisputed that the services at issue were determined 3 times not to be medically necessary in those proceedings they brought on behalf of their son. In this case, they did not even introduce evidence that the services were medically necessary. It is undisputed that DES refused repeatedly to authorize the services that they kept asking for. And it did not say, as Mr. Call has just suggested, keep providing the services while we argue about it. They said very definitely and repeatedly, you are not to provide these services. It is also undisputed that the Maniscalcos knew this from the very first day of August 13, 2012. And finally, it's undisputed that under their contract with DES, DES makes it plain. It does not pay under any circumstances for services that are not authorized. And the access rules make the same point on behalf of Medicaid. It doesn't pay for services that are not authorized. So given that background, Your Honors, you might ask, why are we here? What is it about the argument made by the Maniscalcos that overcomes the fact that their services weren't authorized and weren't necessary? What is it that gives them the right to try to reopen issues that Frank has raised and that only he had standing to raise? And their argument in this court depends on 2 things. One, an irrelevant fact, the forgery on the service plan back in August of 2012, and 2, a new legal argument as to their standing. The new theory is that they had a contract with DES specifically to provide services to Frank. And my argument will address those 2 issues and not some of the subsidiary ones. First, why they don't have standing, even if the court is willing to entertain the new argument on appeal. And second, why the forgery is irrelevant. To overcome the standing problem they have in trying to raise Frank's issues, at all stages of the proceeding below, they argued that Cabral House was a third-party beneficiary of some contract between DES and Frank. And that was plainly incorrect. There is no contract between Frank and DES. Frank has certain rights under the statutes and rules, but there's no contract. And even if there had been a contract, it was clear that Cabral House would not be the intended third-party beneficiary. So the ALJ, who heard this case, the access director who decided it, the Judge Harris in Superior Court who reviewed it, all threw out this theory and said it just does not fly. Rather than try to defend that theory in this court, they have simply abandoned it. And they come to you arguing that Judge Harris's analysis in Superior Court ought to be simply disregarded because she, quote unquote, misframed the issues. Well, she didn't. She responded to exactly what Cabral House was arguing at the time. So now, rather than pursue that theory, they instead try to change the theory and suggest to you that there is some contract out there that gives Cabral House specific rights to take care of Frank and provide the disputed services. Even if the court is willing to entertain this new argument on appeal, it's just completely incorrect. There is no contract for Cabral House to provide specific services to Frank, and if there were, along the lines of one of your questions, Judge Johnson, they would have shown it to you. They'd be citing the provisions in such a contract.
Counsel, wouldn't that be in the QBA? I couldn't find anything in the QBA that would create a right between Cabral House and any individual enrolled in the division's program. Did I miss that, or is that correct?
I don't find it either, Judge Bean. The idea that there is something in that qualified vendor agreement that gives the individual service plans that the provider may acquire some sort of special status isn't there. I don't see it.
Well, I guess I'm confused about how the argument is framed, and that's not an issue that the appellee has. But I mean, I just don't understand. I mean, the state contracted with the Cabral House to provide services to Frank. That's pretty clear. I mean, that's what it was paid for. But I'm wondering how the QVA gives the Cabral House the standing to determine what those services ought to have been.
It does not, Your Honor.
So
the qualified vendor agreement says specifically you will only be paid for services we authorize, and the statutes and rules add to that the services have to be medically necessary. So if you go out and decide on your own, as Cabral House did here, that we think different services ought to be provided, more services ought to be provided, regardless of whether it's medically necessary, regardless of whether you approve and authorize them, we're going to do that. There is no right under the the vendor agreement to do such a thing.
how is this case different from the case that the counsel referenced at the end, the Association of Contractors case?
I think they're completely misreading that decision, Your Honor. That's a decision from this court in which there were two classes of plaintiffs, providers and beneficiaries. In both cases, they had to establish their own standing. The providers were there seeking more reimbursement. The beneficiaries were seeking more services. There's nothing in that decision that says the providers had the right or standing to raise arguments on behalf of the beneficiaries any more than the beneficiaries had the right to argue on behalf of the providers that they ought to get more reimbursement. They're simply misreading that.
Yeah, that was a cut across the board payments for services.
That's correct, Your Honor.
Yeah.
So there's nothing in that decision that helps Cabral House step into Frank's shoes in this case. They've done that. The Maniscalcos have raised those issues repeatedly. They've been rejected. And what you have here, Your Honors, is that the Maniscalcos, wearing their hats as parents and guardians for Frank, would from time to time appeal an issue, and they'd get an adverse ruling, and then they'd stop. They wouldn't pursue it. They wouldn't get some of the hearings they talk about not getting because they didn't pursue it. And then they would put on their hat as owner of Cabral House and say, well, we're just going to continue providing those disputed services as if Frank had won the appeal or as if it was at least ongoing. One detail in their new argument about this contract theory that would give them standing that I think demonstrates how shifting and groundless their arguments are is they say, I believe it's at page 18 of their opening brief, and they try to hide it in a footnote, they say Cabral House provided these services because it had an ad hoc system of adjudicating grievances by its residents that required it to continue providing disputed services when a resident like Frank appealed a change in the services. Well, among the problems with this argument, Your Honors, is, one, it was never made before. Two, there isn't a scintilla of evidence anywhere in this record that supports the existence of such a system. But three, even if there were such a system, they obviously weren't following it, because they would appeal these decisions by DES with regard to Frank, and then go on providing the services long after those decisions were adverse to them, as early as January 2nd, 2013. So that ad hoc system doesn't exist, wasn't followed, and is indicative of how ad hoc their argument here is on appeal.
Talk to us about the administrative, a little bit about the administrative appeal process. I don't know that it's relevant at all, but I'm curious about the shifting burden of proof, whether it's an increase in services or a decrease.
The burden of proof is exactly the same whether you call this an increase or a decrease. The issue is Cabral House, if it had chosen to raise this issue, or the Maniscalcos on behalf of Frank, would be coming to DES saying, you're not willing to provide any more services than are in the service plan. We think more are necessary. Whether you regard that as an increase from the existing level or change it around and say, well, you've decreased the prior level. It doesn't matter. It's their burden
The party who's challenging the
DES.
agency's
Yes.
ISP has the burden.
Correct. DES has made a decision as to what it will provide. The Maniscalcos, in whatever guise they come to that issue, have to establish that DES is wrong and that more services than it's willing to provide should be provided. So even if they had gotten the kind of notice they say they should have, and they had said, we're appealing and we want continued services during the existence of that appeal, the issue would have been exactly the same. Can they demonstrate that the increase in services, the additional services, however you describe it, were necessary? And they tried that 3 times, and they failed 3 times. And we shouldn't still be arguing about that. And as I say, in this proceeding, they didn't introduce any evidence on that issue. So we're left with a record that shows these services are not necessary. They were never authorized. The only thing they keep arguing about is this forgery. And, Your Honors, as embarrassing as that is that anything got forged, it's strictly irrelevant to this case. If DES had to have the agreement or the written consent of the Maniscalcos to change Frank's services, we wouldn't be here. It's never been disputed. Again, following up on one of your questions, Judge Johnson, it's never been disputed that from the day one, the Maniscalcos disagreed and strongly disagreed and vocally disagreed with this decision. There's never been any secret about that, nor any dispute. But the statute, the one I think that Mr. Call was referring to, is ARS 36-560.K, and it says, quote, the department may refuse to provide specific services that are requested by the client, but that are not recommended for the client as a result of the evaluation, unquote. So DES never needed the consent, never needed the agreement, never needed the signature of Ms. Maniscalco or her husband to these changes in Frank's services. And until this morning, Mr. Call has never addressed that statute. They have just consistently said, without authority, that it doesn't matter. They have to agree. And since they didn't agree, there's something wrong here. It's just simply not true. But even if there were some necessity for their agreement, that would have been an issue Frank could raise. It doesn't have anything to do with whether these services were authorized or necessary. They say that, finally, that the determination of what was medically necessary was based on the forged document. Well, that's just completely untrue. The decision to change Frank's services was made before DES came out to see the Maniscalcos in August of 2012 and tell them about it. It wasn't something they sat there and negotiated with the Maniscalcos. The change was simply announced at that meeting, and a forged signature after the meeting didn't cause the change in the evaluation and wasn't necessary for DES to implement the change. So in conclusion of at least my remarks, Your Honor, a service provider like Cabral House only has the rights that are set out in its qualified vendor agreement, the statutes, and the rules. All of these should have made it plain to Cabral House that it could not go out and provide unauthorized, unnecessary services and expect to be paid for it. There is no bad faith by DES in authorizing payment only for services that are medically necessary. If anything, Your Honors, I would suggest that it's bad faith for a provider to bill $350,000 of unauthorized, unnecessary services and try to justify that act by asserting theories that their son has already lost and that only their son had standing to raise. There's no merit to the appellant's arguments, and the decision below should be affirmed. And unless Ms. Falcott has anything to offer or you have additional questions.
Further questions? Anything about DES you'd like to hear? I think we're good.
Thank you, Your Honor.
Thank you. Unless you have any questions, I did a fine job.
Thank you. Mr. Call.
Thank you. The contract says that the parties are going to follow the law. The law wasn't followed here. He acts as if they knew that the forgery existed the whole time. They didn't. There was a meeting. That caseworker forged that document, left. Cabral House thought they were supposed to keep providing the status quo, which had been the status quo for 10 years. It comes to light almost 2 years later that the document was forged through the internal affairs investigation. So it's simply wrong that they can just set the level wherever they want to set it. There's a procedure. Agreement is required to any reduction, and yes, you can change the level without agreement, but if you do, then there's going to be a hearing, there's going to be 30 days notice, and there's going to be a hearing with the burden on the party that's making the change. In this case, it would have been DES, DDD. They had the burden. This forgery lay hidden for more than a year.
Thank you.
Thank you.
Thank you to both sets of lawyers for your briefing and your argument. We'll take the matter under advisement and issue a decision in due course. Now we stand adjourned.